Give for translation if ela. So ne re kopa please respecting our meeting if ela go sena motho o tsamayang ka tsone a re di buseng re utlwana ke re bagaetsho. Honorable members, can we then move on the proposed program? The proposed program is as usual. We are going to be dealing with apologies. After apologies, we'll then receive a presentation from DTIC today. DTIC is represented by Mr. Klaas Mokaba, who will be doing the presentation. And then immediately after the DTIC presents, we'll then receive a presentation from Ms. Riva Velman. Am I correct? Ms. Velman, did I read your surname correctly? Velman. Yeah, we'll get a presentation from Ms. Velman, who will then give a presentation, a very short presentation on the views of the executive on the two bills. Ke lo gopotsa fela ka pele ka je gore kopane mo for public hearing ya rona on the two bills. Those two bills ke the Performance Protection Amendment Bill as well as the Copyright Amendment Bill. So re mo for dilo tse pedi tseo, di bill tse pedi tseo. We will move, honorable members, if we accept the proposed program as it is, because immediately after the presentations, we'll allow members to comment and then we'll give to stakeholders to comment and allow the officials to respond. Can we adopt, Honorable Malema?
Thank you. Thank you very much, Honorable Chair. Lochani, Sanbona, Dumela. I want to move for the adoption of the agenda as proposed, Honorable Chair. Thank you so much.
Thank you, Honorable Malema. Any seconder?
I move to second, Chair.
Thank you very much. Before we proceed, let me also request our honorable members to introduce themselves. I know you might be seeing the names here. We might have maybe reading mixed seats. I will start on my far left to quickly introduce themselves, then we can proceed with our session.
Good morning, I'm Beverly Badnors, and I'm a member of the Gauteng Legislature serving on economic development. Thank you.
Thank you, Member Mkwebo, member of committee.
Good morning, everyone. I'm Nicola du Plessis. I'm a member of this committee, and thank you for making it out in this weather.
Nna ka lebitso ke Mathafeng wa ga Matjeki. Ke chairperson ya committee.
Dumelang, lebitso la ka ke Diutso Paul wa Malema, ke leloko la committee deployed by the African National Congress. Thank you.
Dumelang, lina la ka ke Maphefo Mogalelitsie, ke leloko la komiti ya tlhabollo ya tsa leruo. Ke a leboga.
Now, thank you very much, honorable members. Members, I'm informed by the staff that we are experiencing challenges with transportation. There are quite a number of people, including there's a group that we've requested to come and perform from CDB. They will perform whilst we are still busy engaging on the two bills. But let's move to apologies. I know that we've got an apology from Mr. Dango, am I correct? The NCOP is currently in session. Member Dango is a permanent member deployed to Gauteng specifically for these two particular bills. He's the one that will be presenting our negotiating mandate at the National Council of Provinces. Those of you, Baba, ne le shebile TV Mabani, le bone President Mabani, on the National Council of Provinces to respond to questions from the National Council of Provinces. Ko parlamente renalin tutse pedi, renalin National Assembly, le National Council of Provinces. The National Council of Provinces is there to represent the views and aspirations of provinces, the 9 provinces. All provinces are represented equally in the National Council of Provinces. That's why in most cases, re bua ka ntlo tse pedi tsa tsa parliament. All of them, they are members of parliament, but both of them, they've got different responsibilities. And one of the reasons why Member Dango was deployed here is because of the two bills that we will be dealing with. They are affecting provinces. Bagolo ba ka le ka itse gore di bill tse pedi tse re tlo buang ka tsone tse sala di introduciwa ka sometime 2016 and 2017 ke khale di le teng di le mo sekeleng. National Assembly ibile ya di processor ba di romela ko National Council of Provinces ba di processor ba di romela ko president so that president can enact them into the new act. But when they arrived at the president will have realized through the state law advisors that the two bills were wrongly tagged. They were tagged as Section 75 bills instead of them being tagged as Section 76 bills. In our Constitution of 1996, our world-renowned Constitution, there is sections that deals with bills. In that section, you've got 4 sections. The first section is Section 74. It deals with amenda Constitution. Then renale Section 75. It deals with amenda or reintroduce a molao o ilong gore o national sphere of government only. Then renale Section 76. Elong gore it deals with the bills tse elong gore di affecta the provinces. Then renale last section, which is Section 77. It deals with dilo tse re di bitsang the money bills. Ha re deala ka go approve di budget tsa rona yalo le yalo go ya ka di provinces tsa rona. Now, when these two bills were introduced by DTIC, honorable members, I want to re-emphasize this. When they were introduced by the DTIC, they were wrongly tagged sometime in 2016. That is why they were not enacted into law. But however, not only the taking, the president will have picked up quite a number of issues as in relation to the two bills. He had then requested the DTIC through the National Assembly and the NCOP to firstly tag the two bills correctly, but secondly address issues that the president will have felt that they will not pass constitutional scrutiny if he signs the two bills as they were then. One of those issues, very fundamental, was the issues related to different treaties that we are signatories to, our different treaties. South Africa ke part and parcel and a signatory too. But I think the DTIC will speak well on those issues. Like I've indicated, these two bills are not our bills. Rautlwana Bagaisho. Ki bua la yana cause setse ke public hearing ya rona ya bo 4. Most of the time ha re utlwela stakeholders di etsa di input le super rona ka monwana. Batho ba motile ba super ka monwana ke ba le ka fati. A se rona re tshwana le lona re ba rongwa ba lona. We are here to represent your views and take your views so that they are incorporated into the two bills that are before us. Part and parcel of our responsibility, if you can look at the back, ibuaka public participation. Rona re mo fela go facilitate that process to make sure we get input from you on the two bills. And we want to plead with you, when you make inputs, honorable stakeholders, also make suggestions. It's good and fairly well for you to critique the bills as they are or to support them. If you are not motivating and give reasons as to why you are for or against the bills, you are not assisting our process. We'll end up just taking the bills as they are and say to Honorable Dango, by the way, the Gauteng province stakeholders are comfortable with the bills the way they are. Because the only thing that you will do is to stand up and attack the bills, but you are not giving us solutions. So we are pleading with you that give us solutions If you are saying that a certain section within the new legislation will not work for our creatives, raise them so that we can capture them and they can be part and parcel of our negotiating mandate and ultimately our final mandate, so that we then have a position as Gauteng, but that position must come from our stakeholders. Ra utlwana ke re bagaetsho. So let's have a super if I want to repeat, if only any other issue related to Gauteng Department of Economic Development, elong gore le batla go e raise. O shape jaka tsotsi, wa bona tsotsi Slam, wa bona. A o thoma bua or no chairperson of the session ke nyaka go commenta mo billing, mara ne ke re ka pelenyana wa sha ka economic development o boya go billing. Wa bona? Then we'll take the issues that we will have raised about economic development. I agree, we are members of the legislature and we are a portfolio committee for economic development. So we can't ignore issues that affect our people on the ground. So we can't come here and say, don't raise issues related to economic development, because you might not see us again for this current term. Some of us who will be fortunate, maybe we might come back in 2024. Others, we might not come back. So when you get an opportunity, more bronze plate, the committees here, raise your issues, but Oskaya Holololo. Last week in the Rabatolana Lenega Mike, I guess I also have it clear and ask it's a happy in 20 and go Kurulin. Oskaya Holololo, Honor ha, Owen, office of Buaka Piliga Pillar Hono who move around Kanakabahol. Honorable members, I've got an apology of Honorable Adams. He's still hospitalized. Honorable Albert is running a bit late. Honorable Chair of Chairs, she's attending the NCOP, like I've indicated, or there is a session at the National Council of Provinces. So she is a delegate on behalf of Gauteng together with the Premier representing our province. Can we accept the apologies? Member Letsia?
Thank you very much, Chair. I move for the adoption of the apologies. as
Thank you, Member
presented.
Letsia. Honorable Du Plessis?
I second the acceptance.
Thank you very much. Can we then move to the presentation? Ntate Mokaba, ke kopile thaba go botsa gore o ska ba wa ya holololo. Ono re ting ta into sections tse leng gore di affecta batho ba rona, especially on the bills. Ba ga itse di bills tse di important thata. A ke batla go re-emphasize what I said. Re bua ka molao o leng gore sa lo phasiwa ka 1978 le 1967. Nna ne ke le teng mara ba bang ba lona ne di se le tsalwe ka dingwaga tseo, so it can be correct gore re sentse re na le the acts tsa constitution ya rona tse leng gore di outdated. It's important that we must amend them, and I know others they might be confused, and I've heard Member Malema when stakeholders were making inputs. No, it can't be correct, or yes, after attaining democracy, we still making reference to acts 1978, 1967. Stakeholders and honorable members, it does not mean when you take over government or you amend, even inclusive of the constitution, you must discard what was working previously. If it's working, even if we have an act of 1948, as long as it's relevant, it does not somehow goes against the constitution as it was amended and adopted, we'll still use those acts. But somehow DTIC will have picked up or the current acts as they are not helpful, especially to our creative industries, because you are the most affected in all fairness as it relates to the two bills. It's unfortunate that I always see Tebogo, I always see my sister there. Very few people who are passionate about these two bills consistently. They have been with us throughout the process of this public hearings. It clearly shows that they understand how impactful these acts are to their livelihoods. It's also unfortunate that we have extended stakeholders an invitation to the Gauteng Department of Sports as well as the Portfolio Committee on Sports to be part and parcel of the public hearings. Because in all fairness, Rona, we are just processing these bills as a portfolio committee responsible for growing the economy of Gauteng, but they are not necessarily aligned to economic development. They are more aligned to sports, arts and culture. But we will make sure that we have an engagement with Chairperson Ndlovu as it relates to your inputs, so that we brief him on where you are in terms of your inputs and what are the issues that you will have raised. Let me hand over to Ntate Mokaba to do the presentation.
Honorable Chair, good morning. Honorable members, colleagues from the department, Gauteng Province, good morning. My name is Klaas Mokaba. I am from the Department of Trade, Industry and Competition, and I'll be taking you through the presentation today. Thank you, Honorable Macheke. You've actually made it easier for me, because I think for now, I think they are really prepared in terms of really what is it that we're going to be presenting on. Thank you very much. I'm not going to waste any time, but just to let you know that the bills that we are going to be presenting to you today are very complex bills. I'm going to try to summarize them. You will see that some of the provisions that are contained in the bills are the same. So I would not really be going through all of them as I go through the presentation. What I'm going to do is I'm going to give you the background of the two bills, the Copyright Amendment Bill as well as the Performance Protection Amendment Bill. And then I'll also give you the objectives of the two bills. I would also be taking you through the treaties which form the basis of the amendments that are contained in the bills. And I'll also give you, Honorable Macheke already indicated to you that there were reservations that the President made in terms of the bills. I would be taking you through those reservations and then the process, where we are today, where we are from in terms of the bills, and lastly, we'll then focus on the bills, but specifically to the key provisions that are very, very important, that most of which really affect, the creative industry on a daily basis. Without any waste of time, we are only here to brief you as part of the public participation process regarding the two bills, the copyright as well as the performance protection, and to also indicate to you some of the reservations that the President raised in respect of the two bills. Now, as a way of a background, I'm going to go through this background so that you really have an understanding where we are from in terms of the bills and where we are today. Around 1988, there were really concerns regarding why were a lot of artists dying without anything. They were dying poor, whilst we know that from the music industry, they were actually supposed to be making money. So those particular concerns prompted the establishment of the music industry task team. And around 2008, our parliament then passed some amendments to the copyright to reintroduce needle time. Needle time is, for example, where during the advertisement, where, for example, your music, for example, would be played, so which warrants you to be getting some royalties from that. So that was actually reintroduced again in 2002 by our parliament. And around 2006, my department, the DTIC, we then enacted the regulations for collecting societies. We are going to be dealing with collecting societies also in the bills. And there were quite a number of meetings that really took place with the minister in order to address some of the key issues that the industry was experiencing around 2009. And around 2010, the Copyright Review Commission, which was actually charged with the responsibility to actually look into issues within the copyright, was then established in 2010. And sometimes around 2010 to 2012, a study was actually commissioned to deal with the benefits coming from the industry and really some of the other issues that were identified affecting the industry. There were some campaigns that ran from 2010 to 2014, also anti-piracy, where some of the artists were actually complaining that, their work does not really seem to, go through the market and they're able to earn a living, because of a lot of piracy that was actually happening. Around 2012, there was a project that was actually launched within the DTIC, and 2013, the DTIC then published the draft national IP policy, which then also included some amendments towards the copyright. 2014, there was a regulatory impact assessment study that was commissioned by the DTIC relative to the very same draft national IP policy, which was published in 2013. 2017, the two bills that we are discussing now were then introduced in Parliament. And there were really a number of engagement that really took place after 2017 in 2018 to go on, to address some of the issues which are included. One of those which actually included, the issues on the treaties, which form the basis of some of the amendments, issues relating to the royalties, stuff like this. So there were a number of meetings that actually took place then. Then on the 5th of December, the National Assembly then passed the two bills, and we then began a process of tabling them before the National Council of Provinces. Honorable Macheke already indicated to you the role of the two, the National Assembly as well as the National Council of Provinces. So the bills were then adopted by the National Council of Provinces in 2019. And then we then began the process of then briefing the provinces since 2022. We've already indicated that there were reservations. There were some of the issues that the president had a problem with. All in all, there were about 6. The first one related to incorrect tagging. Honorable Macheke already indicated that it was initially tagged as 75, but the president felt we need to take the two bills as Section 76 to accommodate the interests of provinces as well. That's why we are here today, to also address you, as a province as well. And there were also issues regarding the application of some of the provisions with retrospective effect going back. And the president felt that if we are going to be having, some of the provisions with retrospective effect, that may actually damage or deprive some of the rights that the other role players have in terms of the copyright. And also the president felt that the powers that were delegated to the ministers, especially in terms of the development of regulations, the president felt, no, we need to actually remove the clause because it appears we gave more powers to the ministers to do that. So those powers were ultimately, those provisions, were ultimately removed. And also the principle on fair use, which is one of the key provision or key amendment in the bill. the president felt that there was not substantial consultation on the fair use, then the president felt, no, we need to actually go back and consult more on the principle regarding fair use. And there were really a number of some copyright exceptions. We'll go through them as we go into the bills. The president also felt that, no, there has to be further consultations on them as well. And also the president felt that because of the fact that the treaties played a very important role in terms of dealing with treaty issues, there has to be further consultation, further engagement on the implications of the international treaties. Now, just to give you a brief background in terms of the process of the two bills, the Copyright Amendment Bill as well as the Performance Protection Amendment Bill. The two bills were actually referred back, and then because there were quite a number of issues that were identified, and sometimes around 2021, 2022, the two bills were then referred back. They were advertised for further public comments. The comments were received, but it was felt that, no, we need to actually extend the period, which was extended until the 28th of January 2022, to receive a second batch of comments. Because, like I said, the bills themselves are very, very complicated. So it was felt that, no, we need to really extend the process to actually consult. So, but then around 2022, some of the amendments or some of the proposals were then really incorporated in the bills then, and also to include some of the reservations that were raised by the president. Those consultations also helped to ensure that the members of the public are able to address some of the reservations that the president raised. And they were then adopted by the National Assembly last year in September, and with the concurrence of the National Council of Provinces. We then began as a department to then brief the Select Committee on Trade and Industry, Economic Development, Small Business, Tourism, Employment and Labor on the 25th of October last year. Some of the briefing of other provinces happened just recently because provinces had to actually schedule different briefings in their respective areas. I was in Polokwane last week to address the committee to brief actually the committee on the two bills. Then the provincial briefings, like I said, then began to take place from the 1st to the 4th of November in 6 provinces. Limpopo is one of the provinces that is currently being briefed regarding the two bills. The first bill, the Copyright Amendment Bill. The purpose of this particular bill is to further develop a legal framework regulating your copyright. Like I said, there is a lot of information, a lot of complexities around the copyright legislation. So as we amend, we try to actually strengthen it, amongst other things, to actually make sure that there is a balanced approach between the users as well as the consumers, to ensure that to a large extent we include any other advancement that happened within the digital space, where, for example, we are able to actually access information, through our internet, through our phones, stuff like that. So as we go along, it was felt that we need to move on and then try to actually strengthen some of the provisions within the copyright, and in that way we are actually developing the legal framework further. And then secondly was to also deal with issues regarding the collecting societies. One of the key provisions included to regulate or manage your collecting societies, and to actually ensure that as we put provision to deal with collecting society, ultimately, collecting society need to be accredited by the Companies and Intellectual Property Commission, which is an agency of the DTIs that registers your companies. If you want to register your company or you want to do patent or copyright, so so the CIPC will be an agency to specifically regulate your collecting society as well, and also just deal with any other consumer protection issues affecting the creative industry, the authors as well, and to a large extent begin to deal with some of the contractual issues that were there, because some of the artists, they actually raised concern with regard to the contracts that they were actually signing. So this particular bill seeks to at least ensure that it's standardized some of the clauses or the terms that need to be included in the contract, so that the artists are not taken a right of when they conclude this particular their contracts. Further, some of the key provisions is to deal with the resale royalty. For example, where, as an artist, you're actually entitled to a royalty if, for example, the work that you have actually done previously, if it's actually resold, you are entitled to, to seek royalty in terms of that. Because, for example, some of the work over time, they improve in value. So the idea behind royalty included, under resale royalty, is to ensure that your right actually, protected as well. You can be entitled to something from that. The other issue is to deal with the fair use, which is a new kind of provision included in the bill, to also deal with access of information within your your educational institutions, your libraries, your museum, to make provision that as a person you are entitled to access that information really without having to really seek any permission from the copyright holder, to deal or to accommodate persons with disabilities. So this is what some of the issues that really prompted the amendments of the copyright to really strengthen the copyright legislation. Amongst other things, you'll see within the copyright amendment bill, as well as the performance protection, it also deals with issues relating to technological protection measures to protect any work that an artist has actually done, and to, for example, amongst others, reduce incident where there can be infringement of copyright. There are 5 treaties upon which the amendments in the bills have been sourced from. The WIPO Performances and Phonograms Treaty, the Beijing Treaty on Audiovisual, the WIPO Copyright Treaty, as well as the Marrakesh Treaty, which has played a very important role in terms of advancing the request made by persons with disabilities to also have certain provisions protecting or accommodating them or benefiting them to be included within the copyright amendment bill as well. However, of these 5 treaties, we are only a member of the Berne Convention, which deals with, for example, your protection of artistic or literary works. I know that Cabinet took a resolution some time back to ensure that the South African government ultimately also accede to the other treaties as well. So in future, we may accede to all the 5 treaties as indicated. Currently, we are only a member of the Berne Convention. I am not going to go through some of the definitions contained in the copyright amendment bill. But I'm going to just give you a background in terms of some of the things that have actually been introduced. For example, some terms relating to your technological protection measure has actually been introduced in the bill. Information, for example, where you can actually access a copy in terms of the copyright bill. Those are some of the few changes that has been included under clause 1 dealing with definitions of the copyright bill. Now, in terms of the scope of copyright of the bill, like we indicated, the main objective is to actually, protect anything that has been expressed, anything that is there, and not what a person has in mind. So copyright does not protect something that is still, a thought. It only happens when, for example, you have actually thought, put that thought into something that can actually be seen, that can actually be touched, that can actually be felt. That is the scope of what the copyright legislation seeks to approve. Now, some of the bills within the copyright, talks about, ownership of copyright, where, for example, maybe the state or any local entity or any international organization has been commissioned to make anything that should fall under copyright. So there's a clause 3 deals with that, and the other clause, clause 4, deals with some of, ensuring that as members of the public, you are actually entitled to have any work distributed to you in whatever means, either wire or wireless, whatever the case may be, through internet or somehow. But this particular provision entitles you to have that information communicated to you as well. Now, the clause dealing with royalties, we have already talked about this one. This is one of the key inclusion in the bill to specifically assist in protecting the right of the creative industry stakeholders in terms of them accessing the royalties. And some of the clauses go to as far as indicating that the sharing would be done on an equal basis. And also, the amendments accommodate dealing with royalties in terms of the written agreement. We've already spoken about ensuring that the contracts that artists sign would be standardized. So that would also include provisions relating to your royalties. We've already indicated about, distribution of any artistic work to the members of the public, where they can actually assess, that information. We've already spoken about the royalties. I'm not going to go through this one. There is a provision dealing with resale royalty, right? I've highlighted previously that you are entitled to claim anything if, for example, your work at a later stage, it's actually resold on a commercial scale, where, for example, you are able to actually get something out of that particular sale. So that is what the resale royalty right seeks to do under clause 7 of the bill. The next clause also talks about the distribution of or making information available of audiovisual work. The principle remains the same. You would be entitled to some of this work, even though it really falls under copyright. The sharing of royalties between the performers and copyright, there is a clause specifically addressing that, and that is clause 9 in the bill. sound recording in terms of distribution to the public and making it available also is included under clause 10. You will be able to actually access that either by internet or wireless, whatever the case may be. But the bill makes it very easy for you to then to have that information distributed or communicated to the public and making it available as well. The sharing of royalties further extend to where there are sound recordings. Clause 11 talks about that. But what's very, very key is that a lot of these things would be dealt with by the contracts, the agreement that, for example, the performers or the artists will be signing within their companies. So clause 11 addresses the issue of royalties as it pertains to your sound recordings. It continues under clause 11. I've already indicated that, but what's very, very important in this case is that as the bill was developed, it was important that certain offenses be created. For example, where as a person you do not give the necessary information as it pertains to royalty. For example, if in an agreement you don't really disclose the true royalty amount, that can actually be an offense. And in terms of clause 11, a person can be found guilty of that and then punishable to a fine or to imprisonment. So these are some of the key provisions that have been included in the bill in order to protect the industry. The clause regarding gender-neutral drafting is just to replace where, for example, a word his or her was used to actually replace that with them and their. This is really just a technical amendment in the bill. I'm not going to go through 12. I'm going to do clause 15, which is very important. One of the very important clauses in the bill that deals with general exceptions. To say who can access or what can be accessible in the copyright other than where you get access through the permission of the owner. The first one relates to your fair use. The fair use principle says that you can actually access information without having to go to the copyright owner. That is one of the general exceptions included in the bill. This is one of the provisions that, to a large extent, would benefit your people with disabilities. For example, the blind people who want to access any information relating to Braille, they do not really have to seek permission. But in terms of the fair principle and under clause 15, they are at liberty to access information. It's also covered under clause 15. I'm not going to address that. As well, clause 12B, I'm also not going to address it. The principle really is the same, where, for example, you really do not have to get permission if you, for example, want to access certain information that has been, protected in terms of the copyright. The same goes on under clause 12C, clause 12D. It's just really an extension of some of the exceptions introduced, and which to a large extent would actually benefit your educational institutions, your schools, for example, your universities. If, for example, they want to conduct any teaching or learning, the bill would then allow them to access information without really having to go to the copyright owner to seek for permission. Those are some of the general exceptions covered as part of the fair use principle. Now, another general exception relates to what we call the freedom of panorama. Currently, as we stand in the country, in South Africa, we do not have the freedom of panorama. For example, if you go to Sandton, there is a statue of Nelson Mandela there. So in terms of the freedom of panorama, the current prohibition, you are not allowed to take a picture around that statue and use it. You can't do that. It's illegal. But the general exception now contained in the bill allows you to actually take that particular picture and you can actually use it without really having broken the law. So this is what the freedom the exception on freedom of panorama seeks to achieve. And I know there has been substantial support by other entities, for example, your Wikipedia, because in terms of their model of business, they can actually use this to then really spread information to members of the public regarding the work that they do. There would also be exceptions in terms of your computer program. If, for example, you want to make certain changes on a computer program, you would really be allowed to do that. But obviously, there would be certain limitations, certain things that you need to actually comply with. But for example, you can do a testing, you can do a study, you can do whatever without necessarily having to go to the copyright owner to seek for any permission. That is an exception under Clause 21 dealing with your computer program. In terms of the current of the bill, you would be allowed to actually use, observe, or do a study without having to seek permission. I'm not going to do some of the provisions under Section 22, just only to indicate under Clause 22, Section 19D, that there has been substantial request, submission from Blind SA in terms of removing the limitation regarding them having to actually access certain work that is subject to under copyright. However, it was felt that applying some of the provisions within the Marrakesh Treaty was that we need to actually go further, not to only accommodate the blind people, but to accommodate all the disabilities across the board. So Clause 22, to a large extent, include or embrace all the classes of disabilities for them to enjoy the benefit of copyright as part of the general exclusions. They can do or access any work, any information, really without having to consult with the owner of that copyright. Now, there is a clause specifically dealing with the moral right, which amongst others, authorizes the owner to object if you are of the view or you feel that your work will be destroyed, or if somebody's actually working on your work and the possibility exists that ultimately your reputation may be at stake. Clause 22 tries to actually protect you as the owner, and which then gives you the right to then pursue the matter by a legal action against any infringement that, for example, can happen in terms of the work that you have done. That is under Clause 23 of the bill. There would be a clause dealing with ownership of any work, for example, where it has been commissioned. For example, if a certain company can say, we want you to actually do this for us. So Section 24 deals with that, to deal with issues of copyright in case where, for example, any particular work is a work that has been commissioned. Under clause 25, the clause dealing with, assignment of literary or musical work, we've already dealt with that previously in our slides. And there's a clause that would deal with any work, for example, where the owner cannot be found. And that also include what would then happen to the royalties, for example, that have been accrued to that particular work. So that is actually dealt with under clause 26 of the bill. Now we have spoken about the collecting societies that they would now be subject to regulation in terms of the law, in terms of the copyright, and that is dealt with under clause 27. And they will be subject to accreditation, subject to enforcement by the companies and intellectual property commission. So moving forward, yes, of course, the collecting societies would then be regulated in terms of the copyright legislation. We've spoken already about the copyright management information to basically protect any possible infringement or abuse that can actually happen on any work that has been done, as well as any technological protection measure under clause 29, where, for example, it's possible that your work as an artist may be destroyed or may be interfered with. So these have been included under section 28 and 29 of the bill respectively, and they also create offense, and there are penalties that will be levied if, for example, a person is actually convicted of having contravened any provision that falls under your technological protection measure. This information here is not very important. It's actually dealt with in the previous slide relating to your offenses under your technological protection measures. Some of the clauses here are not really very important. It's just a continuation of the protection afforded to your artist in terms of the clauses relating to technological, so I'm not going to address this as well. Clause 31, not important. The bill makes it important that the functions that are there within the Copyright Tribunal, which is a body that, for example, deals with any complaint or any appeal that is submitted in terms of the copyright. So it was felt that in order to strengthen the tribunal itself, to a large extent, we also need to deal with its functions. We also need to deal with how some of its members need to be appointed, the term they need to actually work as members in office, and to deal with any procedural issues relating to how the hearings will be conducted. In a case where, for example, any copyright or protection, performer protection matter issue has been referred to the tribunal. So the bill also seeks to empower or to strengthen the functions of the copyright tribunal as well. I'm not dealing with clause 35, save that the clause deals with the regulations, which is only a competency of the minister to publish any regulation pertaining to any other issue that is contained in the bill. We have already indicated that issues around fair use, issues around resale royalty right, issues regarding some of the contracts that artists need to be signed. Those would be dealt with to a clearer point by the regulations, which will be dealt with by the responsible Minister of Trade, Industry and Competition as subordinate legislation. Clause 36 deals with, for example, if when artists sign any contract and it is noted that any provision in the contract would not be enforceable, that will be dealt with in terms of Section 76, with a view to really, protecting the stakeholders as well. Clause 38 is just a replacement of certain expressions. For example, the word cinematogram film will be replaced by the word audio visual work, and the word film will be replaced by the word work. So this is just really a technical amendment. I'm not dealing with transitional provisions, but that is contained under clause 39, and the title of this bill, as well the date on which it will commence, will be contained under clause 40 of the bill. So this is just really a summary of the copyright amendment bill, and we are making this presentation so that it be noted for further engagement. I'm not going to take long on the Performance Protection Amendment Bill. Like I said, the provisions really are basically the same as what is contained in the Copyright Amendment Bill. Amongst other things, the objectives are around the performance protection is to really protect the performers, to ensure that ultimately they enjoy their economic rights. Performers, also called badiragati, people who perform. So that's really one of the objectives of the bill, to actually protect their rights, to deal with any moral issues relating to moral issues, to put restrictions on performances, so that they also are protected in terms of, for example, any other any performance activity that may happen. The bill also addresses issues affecting them as performers, relating to royalties as well, and amongst other things, the bill also introduced some new offenses and penalties, if, for example, they can actually happen against any technological protection measure issue or any copyright management issue. So that's just in summary the objective around the Performance Protection Bill. I'm not going to go through the definition. Some of the definition are not are the same as what is contained in the Copyright Amendment Bill. Largely, the objective of the bill is to protect the moral and economic rights of those who perform. As we've indicated, that there has been a lot of concern raised in terms of some of them are really not benefiting from the work that they're actually doing as performers. Clause 3 of the bill talks about the transfer of right. One of the provision included to basically protect the work of a performer, and also dealing with, any issues regarding to regulate royalties that need to be paid to performers as well. Under clause 3 as well, it also addresses the issues regarding the protection of the rights of your producers in terms of sound recordings. For this one, the issue relating to royalty will always kick in. Restrictions in terms of performances that would actually be dealt with as well under clause 4 of the bill, and this relates to, for example, audiovisual fixation or any sound recording. So this also seeks to restrict any use of any performance that can happen by whoever outside who is not the actual performer or the owner of such performances. That is restricted under clause 4 of the bill. I'm not okay. Clause 4 is just a continuation as well as clause 5 also dealing with gender neutral drafting, which is a technical issue. I'm not going to address that now. The regulations in terms of the copyright amendment, the Performance Protection Amendment Bill would also be dealt with by the minister, who is actually empowered to pass any regulations in terms of the bill. And to a very large extent, some of these regulations would ensure to clarify some of the contractual terms or the agreements that, for example, your performers would have to sign when they enter into agreement with their companies. We've already indicated, or we've already spoken regarding the technological protection measures, as well as the copyright management information that's actually contained in the Copyright Amendment Bill as well. And what needs to be emphasized here is that what the bills also seeks to do is to really, create offenses so that when there is a possible violation of these issues, those can actually be dealt with in terms of these bills. Under clause 9 is just also a replacement of expressions. Well, for example, the word phonogram is used, it will now be replaced by sound recording. And then where a word fixation is used, it will be replaced by sound record. This is really just a technical amendment. It's not really very important. Clause 10 would actually deal with transitional issues, not important at this stage. And clause 11 would then deal with the short title as well as the commencement of the bill. In short, Honorable Chair, this is really just a summary. I know I've gone through quickly through the two bills, but this is really, in short, the reason why I'm here, to really consult with you, to get further inputs from you, inputs from you, so that we can continue and then strengthen or revise or improve the Copyright Amendment Bill as well as the Performance Protection Amendment Bill. Chair, thank you very much.
Thank you very much, Ntate Mokaba. Can we get the presentation from Ms. Velman?
Thank you. Once again, thank you, Chair, and good morning, Honorable Chair, honorable members, colleagues, stakeholders, participants. My name is Riva Wellman, and I am from the Gauteng Department of Economic Development. And I'm going to do a very, very short presentation on the views of the executive on the Copyright Amendment Bill and the Performers Protection Amendment Bill. So first off, the executive supports the passing of the Copyright Amendment Bill. From an economic development perspective, the revised bill provides extended rights to creative works as well as the duration of those rights. So contractual exploitation has been the main driver of poverty amongst creatives in the country. So the two main issues have been a bone of contention since 1994. This now has resulted in the alignment of the bill with moral rights, especially the Constitution, to allow for the protection of artists within the creative and cultural environment. So this improved version of the bill clearly increases the support towards originators of work from the start of the production value chain right until the distribution phase. So royalties through this bill will now also be awarded for resale. Mr. Makaba's spoken a lot about fair use. So the right of fair use is now, but in other words, the ability to use other people's work without having to pay for it. It is not an open-ended right. And so it will, I suppose, limit exploitation of work, globally, by globally owned platforms in return for unfair revenue. And then lastly, with regards to the Copyright Amendment Bill, the executive also welcomes the establishment of the Copyright Tribunal, which is regarded as an intervention to drive the protection of intellectual property, especially for disadvantaged artists. With regards to the Performance Protection Amendment Bill, this bill seeks to address challenges faced in the creative industry from the non-payment of royalties, and it will also establish a more formalized creative industry. So this will limit abuse, piracy, as well as protecting the rights of performers. So it will make provision for the protection of not only the moral and economic rights of performers, but also the rights and the protection of rights of producers of sound recordings, and as well as prohibit conduct in respect of technological protection measures and copyright management information. So in conclusion, the department supports the passing of the Performers Protection Amendment Bill, as it supports our vision and mandate of job creation in the country and empowerment through opportunity sustainability. Thank you, Chair.
Member Lisi.
Thank you very much, Chair. Ke a leboga modulasetulo sebaka se ke se filweng ke le dumedisha gape ke nako ela ya gore bjano re tlo buisana. A ke re kwele di presentation ka moka ga tsona. Ke wa re itse gore a la tshwara dilo tse sekgowa tse skene sentle. Dilo tsela tsa go interpreta tsela Chair a ke bone ba dirwele. Ha ke tsebe gore selungu se sa molungu se tsena hantle na. So if kam ka harna re sena mathata a gore re followile presentation, ke tlo bulela matsogo gone bjanong gore le be le di inputs. A ke re o tlhalositse modulasetulo gore re tlile mo go tlo kwa gore lena la reng ka gobane tomorrow ge di tswella pele e ska ba gore le be le tlogetse morago a le tsebe gore na di approviwa jwang le selenka le ba le tshwaelo go tsona. So ke sebaka se la re tlo gopela matsogo a tlebeng a nyaka gore fa di inputs from the presentation. Langkwa langkushisha. Okay. Ke tlo tšea matsogo a batho ba nyakang go bolela regarding these bills. tse di presentilwe mo go lena tshwaelo e le ka bang le yone ke tlo thoma ka le-siteng le if go na le matsogo ba ba nyakang go bolela ka mo le covered le right danki batho ba bagolo go na le ntse ba bitsang brain wave ge o ko mongwe a bolela o se ka tsogela ke malopo wa nyaka go bolela ge re shedi re go file sebaka ko ra o na se o nyakang go se bolela ka mo ba re ba covered ke tlo ya ka le-siteng le la left a re bone matsogo abuti ka ya ke o emisitse letsogo mo gaufi le wena go na le any other hand ka mo o obvious jwang
Dumelang.
I'm still trying to make sure gore ba go emisha matsogo ba gore ke ska tla ka ra ke go kwalela ko ntlo ba o mana le nna it going once twice it's gone so we have two hands only matsogo a mabedi fela le thank you o ka start abuti o ditsebishe o romang o tswa kae
Okay, nake Kabelo Halane, Ketla Soshanguve. My question is simple, is in regards to the amendment bills and all that, will major record labels agree? Because some of these things won't benefit the majors and the collecting agencies, the CMOs and everything. So will they agree? Oh,
o ska eswarela gausi o ye ko tlasenyana gore o ra una shop steward voice gore we can hear you ya ise tlasenyana ganyane
Can you hear
o
me?
inama le yona mosa re ya isa tlase le wena o ya fase yona e ye fase wena o remain still
Ya utlala.
hanyane yan try that way yeah it's
Oh, okay.
better
So my question, Nele, will the major labels agree to all the new rules that are being set out? Because most of these new rules, I don't think they benefit the major labels, especially where the sound recording part comes to. Okay, that's the question. Thank you.
thank you ngwaneso ka dula fase number 2
ne ke re a ke bolele ka tsheko ano ke re ke a lebella ke ra ene ke no bolela ka re ei go kgole mama ke drivile ka ba ka timela o fitlhamo ke a leboga modula stulo ke nna Tebego Sthathu. I'm a singer songwriter composer. Those who are old enough, they know me. If we can still show our pants. So yeah, I think it's a very good question that Uncle Abuti kwa. But Modula Studio, the committee, I'm sure you can see. It's not how they have the question, the question, but issue your understanding. And that's been the biggest concern of ours. How many? Because of this is a very technical, legalistic. There's a lot of legal jargon in the bills. Because of it's only those attorneys, lawyers, legal giants who would actually understand this kind of language. And I so wish that it could be broken down in simple language. You know, intellectual property is a very high subject. It's pitched at level 7, level 8, people in intellectual property generally, university. And I'm an activist, so we are trying to bring this down to the level of communities, of artists, wherein when you speak about copyright, it's not about talking about that language, it's about saying in a song, how many rights are embedded in a song. So that easily can, you know, a person who composes a music or a song will start to understand, oh, can I compose a right? And no wonder I have to be a member of a collecting society such as SAMRO, or as an author or composer. This is where now you start to connect the revenue streams how the money flows, but also le go understand. I mean, if I were to ask a question, or Modula Stulo were to ask a question, how many collecting societies are there and what rights are they managing, each of them? You've got Samro that manages composer rights, author rights, even publishing. You've got Capaso that manages mechanical rights. You've got Impra and Sampra in the same boat, two different societies, but managing the same right, which is needle time and all of that. I can go on and on. And I think it's a responsibility at the DTIC, and also including the economic development. And Modula Stulo, I beg to differ, Ganyane, gore this is an arts and culture matter. I'm one person who actually does not agree with gore artists are about social cohesion and nation building only. We have what we call a creative economy. And intellectual property, by the way, cuts across sectors. So it's important that we need to really bring this discussion to the level of the people. So coming to the presentations themselves, you know, I used to support the bill as they were, but as I studied and I read and I looked at international trends with the introduction of AI, I mean, right now, there's technology that can actually mimic an artist and produce copyrighted material. And then so fair use then becomes a kind of a thorn, so to speak. At what expense are you going to want to make information available? Because also it's a responsibility of government to make information available to society. So, but if now the artist must be the one that makes the sort of information is made available at the expense of the artist who has produced works and they cannot be paid for that work because of it's for education, it's for publishing news, it's for this. I think to a certain extent it's a bit unfair. And whilst we do not want to see us go back because of these bills have taken such a long time. And by the way, let us remember in the first instance why they were created for already amended. It is because artists were dying as paupers. So, but why would we bring now the amended bills which have been crafted to address the issue of artists dying as paupers and then impoverish artists at the same time by expecting artists to make their works available without being paid royalties? I think it defeats the purpose. The objective is good. The sentiment is good. However, I would say we need to fix those key provisions, fair use issue. Is it really going to benefit artists? And all the other elements such as the definition of a performer, because of whilst we talk about the law, we don't want to leave these things to the judges or to the courts to interpret, because of then it's going to be expensive. And Tatebukaba, you know, the tribunal currently is not working very well. And the tribunal is not going to be a panacea for an artist whose work has been infringed upon to be able to run to the tribunal and be happy. They're going to need money to litigate against whoever that is actually infringing upon their rights. So for me, I'm not saying let's do away with the bills, but I am saying it's very critical for us to encourage Parliament to make sure the NCOP that let's fix the critical issues, and then before we can send the bills back to the President for assenting. So I still think that these things, they have not been properly ventilated, and I still believe that artists have not understood these bills the way they ought to. And that is why there's a confusion, and my brother's there saying, will the major record labels support this because of it doesn't really benefit them? Yes, it doesn't benefit them to that extent. However, it also must not cause confusion in terms of the record companies as businesses to be able to deal with artists. Because of if the legislation is so confusing or is left to the courts to interpret, then the record companies are going to be reluctant, my brother, to sign artists to work in partnership with artists because of they will feel that their investment is not worth it for them to invest in artists because at the end of the day, it's not going to make business sense. So whilst I'm an activist, I'm always fighting on the side of the artists. I also must think as a business person to say we need that balance. We really do need that balance. So let's not just fight something for the sake of fighting it. We must also think that when you do business, you put an investment down. You are expecting a return on that investment. And it's very important on that light. The CMOs, I am for 100% that we must regulate collecting societies. But it's a how part. How do we do it? We mustn't do it in such a way that it's going to make it impractical for collecting societies to work with artists. I mean, there's company law that ought to be regulating these guys. Why? They must look at why are they getting away with murder? Why aren't they paying royalties? And there's a conglomeration of facts and factors why royalties are not reaching their intended beneficiaries. So, and up until we zoom into that, we cannot just deal with this thing just on top of the surface because we're just going to create more problems out of the current existing problems. So that's my 5 cents worth to say, let's push for the bills, but we cannot underline, push for them in the form in which they are, especially when there are those clauses that make it impractical for business to be done between artists and record companies, as well as for people to use copyrighted material without paying. So the onus should not rest on the artist for people to have information for education and so forth and so on. Let me stop right there. Thank you so much.
Nekina le matsoga I2 fela ne. Ka re ke sa tlo boa ke campaign a makenya go lentsupe ka menwana. Na le 2 fela ke re bana beso. So we are now going to hand over to the presenters gore ba ke ba phaole from the inputs that the grading from the floor. Thank you. Ke tla starta ka wena ntate.
Thank you, Honorable Member. Thank you, Ntate Tabo. You see, as the department, and maybe as a government, we always appreciate, the attempts, especially from guys like yourself, really in terms of shaping, our policies, our bill, and we have actually taken into consideration the comments that you made. Look, in terms of fixing some of the provisions, for example, relating to fair use, whilst the process to actually engage continues, I think we are well on our way to basically do that. It may not be possible from where I sit to say, ultimately any provision dealing with, for example, royalties or on fair use would be crafted the way you'd want to. But I think we have actually had, we have seen quite a number of submissions, comments that we received regarding fair use. And I think it is true that I think along the way, as we proceed with the bills, there are a number of areas that we need to actually attend as government, and I think would really do that. Regarding the regulation of collecting societies, we are fortunate that at least we've got a provision in the key legislation that addresses or that regulates your collecting societies. It will then be up to the Minister of the DTIC to ensure that whatever regulations that is going to actually promulgate, that would actually, for example, specifically talk to how the collecting societies need to be regulated. That is the point. And we are actually hoping that it will be an area where, as the department, would actually work very, very hard on, to ensure that ultimately we are going to effectively, regulate them. We are going to put, for example, some guidelines. The bill also talks about accreditation, and I can actually tell you there could be certain requirements that needed to be complied with before, for example, CIPC can say this particular collecting society has been accredited in terms of whatever section that would deal with that. But yes, there is a commitment from our side to effectively address your collecting societies. I know that as soon as the bill has been enacted into law, there will then be a process to deal with regulations. And that will also be a consultative process with the industry to ensure that whatever provisions that is actually included in the regulations themselves would specifically achieve the purpose of the section that specifically regulate, for example, your collecting societies. Now, to a gentleman who actually raised a question regarding whether would the record labels agree. I may not be able to say yes or no, but this is what we're actually doing now. This is Parliament. It is the mandate of Parliament to do legislations. So whether people agree or not, the mandate remains. It remains. It is their responsibility to develop legislation. Of course, not all legislations that are going to be developed would be to the benefit of everyone. But the obligation to do the laws remains. So hence I'm saying whether they're going to agree or they're not going to agree should not something that we can really debate upon now. However, the duty of Parliament to make legislation remains, and that's exactly what this government is going to do. We are going to do a legislation that would bring changes that would revise the legal framework, dealing with copyright. So yes, certain sectors of the industry would agree, certain would not agree. But however, it's still our obligation to ensure that we develop and we enact this particular legislation. Thank you.
Yeah, thank you very much. You can give her if there's anything that she wants to say. Does she want to respond to anything or she's okay?
No, she's covered.
It's covered. If you are fine, that's okay.
I'm good.
Okay, thank you very much. Honorable members, why bona brainwave in that table? Why bona brainwave here? Honorable members, you want to comment on the inputs that are made? Member Du Plessis, and yeah, you are the only one. I think the honorable members are covered, and Member Malema.
Thank you very much, Honorable Letsia. I just want to make one or two comments about when we look at the economy. There are three things you need to take into consideration. One is looking after the industry. Because if the industry doesn't work, nobody can work in the industry. It's as simple as that. The next part is looking after the individual within the industry, because, as you know, we as South Africans look after people who are working and employed. And then the third and also very important element is making sure that our local industry is on international standards. Why is this so important? So that we get more investment and we get more people using our services. The more South Africa's services are used, the stronger our economy gets. And I'll give an example. Historically, we all know that we were shut off economically from the rest of the world under the previous dispensation, and that was unacceptable. We need to make sure that every little bit of legislation gives us an international marketability, and I think this is what the amendment is doing. The next two parts, I just want to address the gentleman here who I think is maybe a politician. You spoke quite long, so not a problem. There we go. Look, drama and politics is the same thing. So it is important that we don't just have access to information, but that the information becomes accessible. And I just want you to think about that. Yes, you can read things and they don't make sense, but you as a South African need to also make sure that you educate yourself on these things. And again, this gentleman over here said, initially before he educated himself, he thought the bill was going to work. But the bill in that state would have destroyed the industry. It would have destroyed our international standing. And when he has educated himself and when you, I assume, engaged with people in the industry, you were able to make the information accessible to you. And just the last thing with regards to this bill, I think as a committee we can all agree, we really have seen democracy in action in this bill. It was almost accepted. It was sent back because it wasn't a bill that looked after all the people within South Africa. And I just want to commend everybody here, as well as our researchers and everybody who's been working on this bill to ensure that this bill looks after the industry, the individual, and places us on an international market. Thank you.
Thank you, Member du Plessis. Member Malema, little le re phaphatheleng kaofela, le ska re divide.
Thank you very much, my lady chair. Nakere, hona li re lebohe di tshwaetso tse re di kreyang from your side, from the side of the activists. Hona a question that was posed earlier, Hore, the big role players, maybe in a form of the record companies or institutions, but na the changes tse re tlang ka tsona. I think for all the intents and purposes, it's not necessarily to seek a permission from the big role players. The main aim of this kind of consultative processes is to try and consolidate the views of everyone who's involved in the industry and who's also likely to be affected by the envisaged or the phetogo tse re tlang ka tsona. So it's not necessarily that here buletse and then who's not a voice of the big role players, then it therefore means this thing will not see the light of the day. That's not how it's supposed. That's not how it's going to work. Everyone only a right and reason. Voice high, it treats you with a full human dignity. Even if you are not from a big record company or big record institution, it doesn't mean voice how that's what we need. Because otherwise, if the aim was to try and get the views of the big record companies, the only stakeholder invited to this kind of a session, confined to them. So it's not necessarily confined to those. Big or small, I think all the voices are very much important. That's the point that I actually wanted to make, my lady chair. Thank you so much.
Matsopa, yes, you're doing very well, you're doing very well. Kia leboga, Honorable Malema. I think as I'm going to hand over to the chair once more, few inputs from myself as I agree with honorable members that we are a government of the people by the people. There's a slogan that says nothing for us without us. In our previous engagement in one area, one honorable member raised that if you are not organized, or will come to an engagement of this nature and only find one or two people ba ba leng conversant with the discussions. And this is what I'm seeing today, Chair. I don't want to agree with you, gore it's a matter of language. Ki matter ya content. Are we having the relevant people here to engage with us? And as an activist, I think one of the challenges that you should be taking home, gore how organized are you? Are you saying in this spaces, are the artists that could have been organized to attend this meeting so that they make their inputs? Because we are here. Gore process, I think Honorable Duplessis captured it very well, democracy in practice. And in Nalifa Iwagerena, nobody else. Kausane ge bill ile adopted by Parliament, we are the first people to jump and say how. When government has made efforts to try and get inputs from those that it affects. I don't want to agree with you. Geore is not meant for artists only. And I want to say to you, this is a committee of economic development. It's not sports, arts, and culture. And that's the reason why this bill is placed at the doorstep of this department or this committee, because the understanding is that it's not only affecting artists. It affects the entire economy in terms of protecting those that are participating in the economy and as well as the livelihoods of such. So it does not only affect the artists. And I am going to say, as we leave this meeting, go into process, I think we are convinced with the chair that we have tried to solicit inputs. You should not be roving around Uliwane Ndatetebogo. No sanju plakile batho in all these regions. That will make exactly the inputs that you want. And I think it's a lesson that we are learning. I think for public participation as a committee as well, it has opened our eyes, and in future when we make such a participation, I think through the chair, we'll look into who we'll be addressing, whether it will give us the necessary outputs or not. Akinya go tswalela ko ntle ne, mara o tsebe gore wa disorganize. Because one disorganizer, because I said you must speak and wabulela ka fast back. O ka nna wa bolela ngwaneso. Ke motsotso ka o take ya go balela clock e kae? 1 minute. Le ntshinyetsa motsotso jwale ka mic. Yeah, you can. No, you need to be recorded. Ba go record le gore out of order, that is why le ka se be organized.
Okay, but Chair, you know, because of so which means more time to talk. So, and by the way, I don't represent myself, and I want to agree with you. This cuts across sectors, but also this is a challenge to. And I'm also learning. You are 100% correct. I should have planted more people. That's how you actually, we multiply, like Mama Winnie. However, economic development and DTIC, the issue of outreach, IP is a very complex subject, and I don't want to intimidate everybody or anyone. It's like mathematics, but it's a fact. There's no way you will not find legal jargon. There's absolutely no way. And then people... like they used to say, I see my fighter, Malema wa flip-flop. If you know where I stood first, you think I'm flip-flopping because of, and she's quite right, Honorable Duplessis, because of I was like, no man, when I first interacted, and I'm saying these things because of my colleagues will learn from me, how I got to grapple with this thing. It was so intimidating, even for me. And yet I was exposed to law, and then at some point in my life. And then I saw the people that were actually against. And I said, but why is the young man's question, the record companies, the major record labels, collecting societies, will they support this thing? They formed themselves into a coalition. And I saw them opposing. I said, no, this can't be right. Why would these people oppose, and yet they're exploiters? And I jumped in to oppose them instead. But I didn't actually have much information till I had to take the responsibility, and which is an encouragement. Honorable Duplessis has mentioned it. It's important that you go out and get the information yourself. Don't just listen to people. And I started researching. I started digging and digging. And in my digging, I was just opposing for the sake of opposing because I said, no, these guys, they are chowing us, Mara. They don't want this bill to go through. But then I said, somebody's missing in this discussion, the artists themselves, the creatives. When I began to engage with them, and I realized, I spoke to my comrades, who, from an artistic point of view, and I wanted to know, what does EFF think? And I realized that when it comes to the fair use, everybody kind of agrees, but there's certain provisions that are highly contagious. I spoke to Bujin Teto, I spoke to other artists, and I said, but you guys, why aren't you out there on this bill? Why is it only me and one or two artists? And I realized that they always saying, no, Debza, we are supportive of the bills, but hey, fair use is like piracy. And I started to delve deep into that. And when when now the new things, your ChatGPT, you know, these new platforms, ChatGPT, your AI stuff that is coming very strongly. I realized, no man, we are in danger here. If we do not guard against our copyrighted material, we are going to find ourselves that we've pushed this fair use out of the fact that the US, because of their use, they have fair use in their jurisprudence, then therefore, because of the US has got your big Hollywood, they are successful in the creative industry, so therefore we are going to succeed. But I realized, no man, we have to, I think one honorable did speak in the last meeting about the issue of making sure that we adapt to the South African situation. And the African situation. So I realized that if we push some of these provisions here, we are opening up a floodgate, not only because of once you have this in South Africa, the rest of Africa is looking up to us. Then you'll have this floodgate of fair use. So the issue of royalties flow, certain things can be done, even with the current legislation. Issue of reciprocity. And the issue of local content, I still believe it should have been key. I mean, I'm sure most of my colleagues here who are musicians, they will tell you, most of the time the music they hear on radio, South African media, is not really South African. Including your cultural stations, there's a lot of content that comes from abroad. And unfortunately, it sniffles out our royalties. Because of when you talk to the coalition societies, they will tell you, what shall we do? The music that is being played, that is dominating, it's because of this their music. So we must pay them. So we have a lot of royalties leaving the country and going to pay people that don't even have Needle Time. I mean, I'll tell you a story about Needle Time. Needle Time as a performance royalty, when even within that regulated space, a lot of money still flows out. Why? Because of when Mahlatini, the legendary Mahlatini died a pauper, that's when the South African government brought in back the Needle Time right. But if we do not push for local content, I mean, it takes a minister. In Canada, they do it all over. A minister to say 90% South African music. It was not a Saudi thing. We supported Saudi because of he came with something that was bold, a bold move. And he was attacked for all sorts of other things. We don't want to get into governance. So people conflate matters and issues. The issue of 90% is critical so that the more South African content you hear and you see in our platforms, the more money will stay in the country. So what's the point of having South African music rights organization that is saving the American music, American musicians, because of most of the money has to be sent to them because of most of the time we are playing their music. So honorables, in conclusion, I'm saying we need to really already gogolos this thing, IP. And it's even beyond the signing of these bills, there's regulation and there's actual education of artists about this copyright that regulates authors, composers. You've got designers, young designers. Why do you have Kobo ya Basotho, Visage, and it does not benefit Basotho? So all these things, we need to bring that education to creatives in the best way that they can understand what intellectual property is and means. Thank you so much.
a ke a go kgetha wena ke a joina ntwe ene ke tlo vivisa gore o kgethiwe. Thank you very much for the inputs. I think the passion e o nang le yona for the industry and the subject matter, it's a passion that we wish could be drilled mo ditlhogong tša all those that are participating in this industry. However, my point is still, because some of these traits are God-given, because being an artist is something that you don't learn in most instances. It's something that is within you. We take it for granted that we can run it on our own. We don't understand why companies run a legal department, HR department, and so on and so on. Because you acknowledge some of these areas I will need some advices. Necessarily as an artist, you don't need to understand the law. There should be people who help you to interpret the law. So that's why it takes time for these engagements. That's why it takes time for all of us to find each other. But I'm happy you are saying in the bill there are areas of agreement. There are those areas that might need further engagement, and maybe, like it has been said in previous engagement, a middle ground. How do we find each other and come up with something that can work for us all? Like he has said, government's responsibility is to pronounce on legislation. So we'll have to have something that regulates in the meantime when other issues are being engaged, in case we are still not agreeing on all the clauses. So on that note, I want to hand over to the chair to conclude on the session. Thank you very much. Thank you.
Yeah, no, tla ke leboge modulasetulo wa sebaka. Committee yaka is blessed that I've got two chairpersons serving in my committee and a whip, and whips in fact serving in my committee. She's also a chairperson of a very important committee in the legislature dealing with legislation. I think I don't started with this process. And sometimes we tend to conclude that those who are within a certain sector, they are not well vested or educated enough on certain issues. And listening to you, and I agree with Member Du Plessis, maybe you need to reconsider your career path. Because one of the most important tools that the former President Mandela, would have encouraged us when he left prison was to make sure that we educate ourselves. And I can assure you, an educated mind, you will never defeat it. And I'm happy that when you started, you were supporting the bill. But what made you to really have reservations, not to say you are not supporting the bill, to have reservations is because of you read. And you read to understand. Because reading, sometimes we might conclude that, oh, he read the bill, so what? But once you read, not to read to understand is something else. And I have went through 4 public hearings. Because I've said when we started, we are here to facilitate a process of stakeholders' inputs. But it does not mean that we also have not picked up what might be the challenge with the 2 bills. And today you spoke exactly the words that were spoken by the President, especially as it relates to the fair use. Because it's fairly good to want to address one issue. But once you address one issue by creating another issue, you are going to have a serious problem in your hands. And I think DTIC, they are listening. to your inputs. I think Tabo and our researchers, they are listening to your input, because where I'm seated, I also have the same reservations. In Johannesburg, when we met majority of stakeholders that operate within the industry, I asked them one question. I said to them, after a very lengthy discussion, I said to them, all of you here, I take 90% of you or 95% of you drove to this venue. The first question I asked them was to say, can I get your car keys? And most of them, in fact, all of them refused. I said to them, can I get your wallets? All of you. I want to take the money in your wallet and donate it to charity. And they refused. And if you can analyze that input that I made with the fair use input that you are making are aligned. You can't have a situation where you rob Tim to pay Peter. It can't be. Because currently we are saying we want to formalize the industry. But with this process that relates to the fair use, we are creating a problem. We are saying your intellectual property must be expanded to academics. But why aren't we paying you for what belongs to you? It's what fair use is all about. Why are we paying authors? We are paying them because of their creatives. It's their intellectual property. But in libraries, all the books that are in libraries, people you might be thinking they are free. But those people were paid. But why, when it comes to the creative industry, especially artists, we are saying, no, by the way, if your song has got something to do with traditional music, we must allow it to be used by the academics for free. It does not make sense. If we are serious about making sure that our artists, they don't die as paupers, we must also address that part. But most importantly, and I think it's what the executive will have raised as their view, and I said to them, Ms. Velleman, I said, you are making a mistake. Part of what you are saying you are supporting as the executive, you are also raising an issue to say we must regulate the payment of artists. We can't be saying, hey, by the way, there must be a basic salary for artists. It can't be. It can't work. Because Tebogo, as a person, is an employer. You know, they are supporting artists, they are dancers, they are makeup artists. There are a whole lot of value chain involved. I can imagine if a provincial government comes and says, Tebogo, basic salary, 3,500, you will tell us, it's not going to work. The regulation and making sure that artists and the creative industry are recognized as employees within South Africa is very important. And I think you have emphasized this part on a number of our public hearings. But the manner in which we want to do it, we must also relook into it. Because we can't start to even introduce a basic salary. It will be a problem. The same problem that is being faced by our athletes, especially in the PSL. If you know the fights currently within the union and the PSL itself. It's basically on the basis that Tebogo today, if he joins TS Galaxy, performs exceptionally well, and he needs to move to Orlando Pirates, Tebogo must be given an opportunity to renegotiate his salary. It can't be on the basis of a basic salary. It can't be. We must pay people based on their performance. That's as simple as that. But we hear you. I'm not saying it's our position. Tebza. We've heard the inputs, but surprisingly is that the question that was asked by the young gentleman that was there, a very important question. And when Member Letsoalo was saying you are not organized, I agreed with him. Member Litsi and Member Letsoalo, both of them. Last week, Member Letsoalo raised the same issue of our creatives being organized. But you see, South Africa is a country where it's always about survival. When you wake up, you are thinking about where your next meal will come from. Once you organize yourselves, it means lawyers must be paid, people must be transported, meetings must be booked. But your big companies, I'm sorry I'm going to use a politically incorrect word, but because of I'm elected, I will use it. But big white monopoly capital, they can simply use the resources that they have to really fight, especially a system that they think it will affect them financially. And that's what I picked up about these two bills, that part and parcel of those that are opposing these bills to pass through, notwithstanding other sections within the bills that you will have correctly raised them, are on the basis that it's going to affect their income. Simple as that. That's how we will have picked up. They are not looking at a bigger picture. They are not looking at us trying to regulate currently an industry that we feel is under-regulated. We are not saying you are not regulated. Hear me correctly. We are saying it's under-regulated, and it's our responsibility, Member Litsi, like we've correctly said it, that as elected public representatives, part and parcel of our responsibilities is to make legislation that is user-friendly, that is going to benefit our people on the ground. And these two legislation, much as we might have reservations on some of the sections that DTIC is proposing, and that the President correctly will have also raised them, it's important that we must pass these legislations so that we are able to address other issues within the legislations that are not necessarily assisting our people. We have somehow came to the conclusion of our public hearings, but we want to request stakeholders that if you want to make further inputs, because at least we'll have about 3 weeks to finalize our negotiating mandate, please submit your input to Skosana, Thabo Skosana, Skosana @gpl.gov.za. skosana@gpl.gov.za. Please submit your input so that by the time when we finalize our negotiating mandate, we are able to incorporate what you will have raised. We've heard what Thabo and the rest of the other colleagues will have raised. Thabo, when I said these bills, they affect the creative industry, I knew what I was talking about. I was not saying we don't appreciate the creative economy. All I was saying was, much as we are tasked with the responsibility of making sure that these two bills gets to be amended so that they assist the creative industry to grow our economy and to create sustainable jobs. But 95% of these two bills, they affect the Department of Sports, Arts and Culture. We are not ignoring the fact that this portfolio committee or the Department of Economic Development, it cut across all the departments. We are the only committee where we know you speak of health, job creation, education, job creation, inclusive even in those two departments, economic growth, because you've got people who are suppliers in those, but we know our responsibilities. But what we're asking was to say, let those that are within the industry participate in making sure that they make inputs on the two bills. Hence, we even extended an invite to the portfolio chairperson as well as the department. And before we finalize our negotiating mandate, we are going to have, honorable members, through TAB, a joint sitting with the portfolio committee on sports, so that we take them through the inputs that we will have received from stakeholders that will ultimately impact them moving forward when we start implementing. Because the amending part is something else, but implementing the legislation is something else. Because once the legislation is starting to be implemented, it will really affect that department on its own. Honorable members, thank you so much. Stakeholders, thank you so much. Before I close, there is a group from Sebokeng. I hope you are ready. They are going to give us an item. I want to humbly request all of us, these young men and women, they came all the way from Sidibeng to come and perform for us here in Bronkhorstspruit. And by the way, they are doing it for free. We are also abusing them as a portfolio committee. But it's because of they understand Tebza. Firstly, the passion that they have and their marketing strategy. Very impressed. That's how you market yourself. Where there are an audience and you've got a talent, don't sit with your talent. Make sure that you really market your talent, so that tomorrow we will know wherever we are going, we will use them and they will be compensated for their performance. So I want to request the team to come forward. Please, let's give them an attention and let's listen to what they will be presenting before us. You can come, Banabesu. I don't know. Speech.
Yes. We are ready. Thank you so much. Thank you so much. Yes, we're here. No, just. I grew up as one of those kids who never had access to success. Key to success was never obsession. I had options. My options were auctioning and auction for a piece of scaf. Eita, fede makala, the broco, stopping the progress. I left my father in the dark to light up the streets. addiction, dedication, no education, decision making was all about the craving. So nginitshela ukuthi ama-drugs ayabulala. Hi. Iphi phone yami? Where's my phone? Yeah, mkhulu. Yeah. I mean in Brokenfontein. Yeah. We are in taxi I4. There is plenty of food. Please bring 4 condoms. Yeah. And bring my cousins about Joske. Please. Yeah. Make sure. Yeah. Yeah. Whew. Yeah.
Kelly. Where is she? Kelly. Oh, cool.
Yeah. Ulabani. Nakubona ulabani. What want? Huh?
How have you been? It's been long.
Hey, mina ni rice one bona na jeka ni jelly na titimela ni.
Wow. Your style, man. You look stunning.
Oh, outfit. Yeah, gogo ya mina design. Gogo Caterpillar. Lawyer strong. Yeah, nani enzele outfit le.
No, I can tell.
Yeah. Hey, nakubona wena. Iwe na producer yangu na mina ne. Ukoma wana mina ma music video wena. Ukoma wana mina ma figure wena.
No, Mkhulu. I manage her.
Oh, manager. Oh, manager. Laba man manager na mina ni artist wabo. So ni bama songs wabona ni ya ni kola nice.
You can give me something. Maybe I can sign you right now.
Oh, audition. Oh, producer. I want beat. Ni get the beat. You go ding.
Okay.
Yeah.
Ding.
Chauke.
Ding.
Chauke is coming.
Ding.
Chauke is the best.
Ding.
Chauke.
Ding.
Ah, Chauke.
Ding.
Yeah. You see, talent is big. I want my music ni wafambisa Giyani. Bati bakur Giyani. Chauke is the best. Ni shabisa masidi yami na 10 rand. Ni enda ma 20 rand, na 5 rand, na 7 rand.
No, Chauke, it doesn't work like that. There are protocols.
Oh, wena nakubona wena. Oh, mwana mina you abuse mwana mina wena. Nibonile mwana mina TV, bamutsuzumisa emabhomu, ma helicopter. Hey.
No, Mkhulu, it's not like that. It's entertainment. She was just playing a character. Everything is scripted. It's just a film. And the last one, it was a movie.
Okay, aku ima royalty mwana mina is poor. Akakhona ukupatala meati, akakhona kushaba ndlu, akakhona kushaba mova. Uwabhiza uteka ma royalty mwana mina wena.
You know, I don't like repeating myself. I try to be calm. You know, I own her.
Hey, mwana mina, anikuchabi wato, anikuchabi. Oh!
Yeah, you know, like I said, I own her.
Yeah.
I tell her what to eat, what to wear, what to drive. She belongs to me. The minute she signed that contract, she never read. I can see where she gets her foolishness from his old man.
This is a reminder to you. Before you get into any agreement, make sure that you understand and concentrate.
You know what? I think I'm done with you. I left my business card. She has my numbers. You can tell that drug addict of yours to give me a call.
Okay. Look, sign a contract. Concentrate. You must concentrate, understand, or else you will cry for a lifetime. Look, who are famous. Understand the contract, man. Sign the, my music is playing every day on the radio, my soap is on TV. Did you read the contract? Okay, what I mean. Sakan!
Oh, Mkhulu, it's you.
Yes, it's me.
Mkhulu, what day is it today?
Yeah, it's the day, obvious.
No, Mkhulu, it's your birthday today. Happy birthday to you.
Happy birthday, come on.
It's your birthday, Mkhulu.
Oh, it's my birthday.
Yeah, Mkhulu.
Oh, today is my birthday. Nilaba ko jama danono. Nikata 23 time mayonnaise. Yeah.
Mkhulu, how old are you today?
Oh, how old are you? For 20, no. Nico, no, 21.
No, Mkulu, you're 58 today.
Oh, yeah, not 58 months.
No, Mkulu, not months, yes.
Oh, yeah, whatever. Yeah.
So, Mkulu, tell me, what happened yesterday? I was waiting for you at the airport.
Oh, at the airport. No, Mkulu doesn't take place. Shaboma Shlolisha. Hey. Look when you fika airport. Ningene imilenge mbilu yami ayitsotsuma. Aeroplanes. Shaboma. Boom. Ni checkile movie Titanic uboma ama plane. So, ni take a taxi.
Mkulu, how did you get here? Tell me how you got here.
Nifika Joburg. Ani tibzala ko bana ba Joburg bana le ranzo. Look when you fika Joburg, daddy let me help you. Ni ba niketa mabag ya mina. Uko ati daddy ni ko pela favorite ni mo niketa wallet. Nifamba like king. Look when you jika akusana munhu. Look when you jika bateka mabag ya mina. I hate Joburg. Nakubzela. Ay.
Mkulu, you don't have to trust anyone in Joburg. These people are thugs.
Mina, I'm from Guyana. Look, when you fika Guyana, nitateka Raja, niteka Paloni, nifaka Dispring. Nitamuloya strong.
Mkulu.
Yeah, nifaka Dispring na mix. Uta buy headache, uta ngena Guyana tutsuma. Nakubzela.
Mkulu, you won't get your things. Forget about them.
I want stress mina man. Wabona mina ni right. Wabona mina ni fuma ni boy ani straight Zimbabwe mina. Wabona. Look when you fika Zimbabwe bako madala passport. Ni check left ni bona razor fence. Ni jeka ni bona mapolice. Ngena razor fence na jumpa na South Africa mina. Yeah, ni ngena mahala South Africa mina.
Mkulu.
Look when you jeka look when you ngena border. Ni check left ni bona lion. Hey. Mhleketi wa mina uri Kruger National Park. I should have paid the passport. Yeah, what do I look on concentrate straight. Ni ku choke concentrate. Ni cheka ni bona lion. Ni ku choke relax. Look on cheka right ni bona a soldier man. I come AK-47. Aish. Look on cheka lion. Mbilu ya mina ku.
So what happened, Mkulu?
What happened? Any dumulile man, ni feel.
Mkulu, but you're still alive.
Yeah, ni fukile. Yeah, and wana mina nilaba kukuteka ufambo ya Guyana and please look give la crocodile ungangoki la Costa.
Why, Mkulu?
Yeah, not wear la Costa when croaking crocodiles. Yeah, look give la crocodile goke la Costa. Crocodile shabona kuri hey uteke ngwana mina mupecha la. Siko bang. Yeah.
So, Mkulu, who were you talking to?
Oh, a friend, I mean, Philemon.
Philemon?
Yeah, Philemon. We are in Mozambique.
Why don't I know him?
Yeah, one man. And when you take my drugs, when, eh? A musician, a go my newspaper. 1 minute, take my drugs. Why take my drugs?
Mkulu, you won't understand. Being an artist is difficult. Always booked, performing, no time to rest, getting paid once in a month. A normal human being won't cope the work I do.
Knock. Sanbala Mkulu.
Yeah,
I'm telling Kelly B.
Yeah, it's Kelly B. Yeah, he's here.
Sis Kelly B, une 3 months ungapatali moto. So ungapatali moto namhlanje sayithatha.
You know what? Just take your car keys because I won't be able to pay for the car.
Mkulu. Who's your designer?
Oh, Gogo Yamina Caterpillar designer. She lawyer strong.
The outfit look takes less. Even if that person won't wear that.
Thank you. Yeah.
You know this girl is underestimating you, Mkulu.
Why are you taking drugs, man? Nateba was celebrity, Maro. Don't take drugs.
Mkulu, it's a long story.
Where we come from in the Val, there is high rate of young people who are into crystal meth. Yaboni crystal, yafako itotsitale kaslam. Aksi krimora no mimpupu yama Russian. yitshe riding ishaya wonke umuntu onganamuntu onomuntu alahla umuntu indoda ishiya umuzi intwana igijimisa inamba. Wait until you crave and crush izinto zama all-star lobster laws riding. It's all about pulling the plug. Ifak life lena ubashasha abashiya abantu bakhala bakhamisile nokia si 2017 bahlezi bathengisa nge-stop price. Baleka gela ungayibambi boy iyokushaya uze ungathi une-back left flat tire. Mike Tyson nge-attitude yamagrega yenza i-body heist. Weight loss, slender size of a charger. Mentally continuously subtracting, always adding one ukubhema. Be careful udla ama-carrots. Ngeke usabona kahle umoshela abantu. Thank you so much.